This week in Seattle, 3 federal judges heard arguments in a case that we've been following here on the story for more than a year now. It's about a mom in Malheur County who wants to become a foster parent and adopt kids from the system. But the state has denied her certification because she told them she would not support LGBTQ plus kids in ways that the state requires. Jessica Bates is a single mom with 5 biological kids already. She says God told her to adopt 2 more kids. But Oregon's Department of Human Services requires that parents to support the LGBTQ kids, including using their pronouns and providing proper medical care, including gender-affirming care. She told them she would not do that because she's Christian, calling those things child abuse. Bates is now suing the state of Oregon in federal court, trying to get that rule suspended. Late last year, a judge in Oregon denied her request, saying she had no right to force foster kids to align with her religion and its beliefs. Her attorneys appealed, claiming the state is curbing her freedom of speech and religion. They made their oral arguments yesterday in front of the Ninth Circuit Court of Appeals. And by the way, the federal court earlier this year made a change that allows judges to let video cameras into the courtrooms if they want. And I think this is some of the very first video that I've ever seen from a federal court of appeals case. It's routine in state courts, but it's still rare in the federal courts. Okay, here we go with the attorney for Malheur County's mom verbally jousting with the judge.
And I really have trouble understanding how this is inhibiting your client's ability to express her views or practice her religion as she wants.
Well, Your Honor,
the only focus is on the child and what she says and how she treats the child, not the rest of the world. And if the best interest of the child is supposed to be the uppermost priority from the state's perspective, responsible as it is for children in its care and custody, how is this viewpoint discrimination? Your client can say whatever she wants to anybody else.
Oh, well, Your Honor, that's never been, you can always speak your other message elsewhere, but here the government is essentially conditioning a benefit or a license on my client not expressing her particular views. As the district court said, inherent in the rule is that my client cannot espouse certain views on LGBT status, and the way the rule operates is on page 31 of the record.
Not espouse, speak to the particular child. She can espouse all she wants to other people.
Well, Your Honor, it's, I don't think we should force the Muslim family to say, you can't explain your religious beliefs in your own house to people in your own household. That you can hold these beliefs, but you can't espouse them.
The state argued that Jessica Bates is allowed to hold whatever religious belief she wants on her own and with her own biological kids. But with foster kids in her home, the state lawyer admitted there would be some things that she could not say.
Are there things that she cannot say to the children in the home? Would that be your position?
Yes, Your Honor, but I don't think it's quite as restrictive as plaintiff would have it. So the state is not trying to extinguish plaintiff's viewpoints about human sexuality or gender identity. And of course, that would present a constitutional problem. What the state asks plaintiff to be able to do is to, in recognizing that she does hold those beliefs, be able to parent or provide childcare to a child that recognizes that that child might be different and might not conform with those beliefs that plaintiff holds, and to provide childcare in a way that respects the child. So that might mean that there are certain things that plaintiff couldn't say to the child. Telling a child that homosexual, if the child was homosexual, in the state's view, the plaintiff could not tell the child that homosexuality is a sin and the child, would go to hell.
The judges also questioned how selective foster parents are allowed to be after they're certified.
Can an applicant for foster care, if the state calls a Christian family and says they have a foster child who's Jewish, does the system as it exists now allow the state to not make that pair, to allow the individual to state that preference?
So that would be something that would happen beyond the certification process, which is what this rule takes place at the front end, at the certification
I understand
stage.
that, but when you get to the certification process, Do you allow some selectivity and matching?
My understanding, Your Honor, is that no certified resource parent or adoptive resource, I think, is required to take any given foster child into their home. And I think that would be up to them to
system allows
decide.
Opt-out, if you will, based on
Correct.
race, gender, religious affiliation.
The decision is now in the hands of those 3 judges. Again, Bates and her attorneys want the state rule suspended. This says the foster parents have to support LGBTQ plus kids in those specific ways that we mentioned earlier. No word yet on when the judges could make their ruling, but when they do, we'll be sure to let you know.